There's a guy who's all over social media over the last week or so claiming that Kim Kardashian ruined his life over in a lawsuit over what is called a Kimoji. A Kimoji is a Kim Kardashian themed emoji set that was sold on the App Store for a while on Apple that he says that he came up with the idea for. This guy saying that he's now homeless, that he had to sell his $2 million house and lost $2 million, that his wife left him, that he contemplated suicide. And he's saying all this was over a legal fight that he had with Kim Kardashian about these Kimojis, about who owned them. And he says that Kim Kardashian buried him, that she got the best lawyer in Hollywood, a guy named Marty Singer, that he came after the guy who's all over saying that his life was ruined, and that these Kimojis basically did him in, and then he's done. So what actually happened with this, and what are the details if you go through the lawsuits? My name's Kevin Nooper. I'm an attorney at Nooper & Covey, and I've gone through, found the lawsuits, found an arbitration award, and found the contract and some of the details and what's gone on with this. So how did this guy get where he was, and what kind of lessons can we learn from this, and what is all the drama about Kimojis, and how can they destroy your life? So the first thing you're probably wondering is, what is a Kimoji? And so here, just so y'all can see what these things were, they are defunct now, so I'm not sure you can go get them anymore, but they were basically Kim Kardashian themed emojis. These are the most like family appropriate ones that I could find. I had to sort of clip out a few of them because it is hard to actually get a selection of them that are family appropriate. These are ones you can see her crying and just pictures of her with the different hairstyles. There were many of them. What I think might have been selling it is sort of various body parts that Miss Kardashian is most known for, and you know, that being her derriere, as the French would say it, and they would have just sort of a little Kimoji of it, and a Kimoji of various things that maybe weren't entirely appropriate to send, certainly not in work environment or something like that. But they kind of look like this, and there were a lot of them, and you could pay to get them on the App Store. And she made a lot of money on this. At one point, it became a huge like kind of fad type thing, and was selling like $1 million a minute in these things on the App Store whenever she launched it. So there was a lot of money that went through that, where people were buying Kimojis. Was it teenagers? Was it people who thought it was funny? You know, I can see how this would be funny to send some of those things to your friends for like, you know, a couple days, and then you would be done with it. But worth a couple bucks to do. Maybe a lot of people might have had fun with this. But there is a reason that they sort of went kaput by the end of it was not a long-term fad that lasted. This is the guy who says that Kim Kardashian ruined his life. His name is David Liebensohn. He was involved in litigation in Oklahoma and then arbitration after that with Kim Kardashian, and I'll explain all that to y'all as we go through this stuff. So he has been on TikTok. He's been on various places, a lot of news media articles about him recently. And he basically has this website that he started and says, my life is over. I'm living in a car in Los Angeles. My family's gone. I had a rift with my daughters because they loved the Kardashians, and I was in this big fight with the Kardashians, and this legal battle destroyed me. And it sounds like it kind of did. The question is, I guess, sort of, was he in the right or was he in the wrong? And I'll go through all the arguments that both sides were making on this. You can decide for yourself who was right and who was wrong in all this. And frankly, we just all we have is what they have alleged against each other. We don't, from our perspective, who knows the truth? But we do have a decision from an arbitrator, which is the ultimate, and we can see that it was filed in a Los Angeles County Superior Court. So we will get to see what a retired judge ultimately decided the facts were, and then you can make your own sort of whatever you think is whatever you think. And so he says he is definitely all over social media, and you may have seen him if you may have come across in your TikTok. What does Mr. Liebensohn say happened that led to all this? Now, at a high level, so he says that he is the one who came up with the idea for these Kimojis. He says that he and a group of friends were working on this app called Censorgram. And the idea for Censorgram was to stop online bullying. So it was something that would sort of restrict content that came to your Instagram account or whatever that might be bullying. So it would sort of help teenagers or whatever, or parents keep their teenagers from being bullied by having like a filter between them and anybody coming in and sending stuff to them that they shouldn't. And then it also, he says, I'm getting some of this from an interview with the Daily Mail. He says that he was also simultaneously creating sexy content for these emojis that were his own sort of emojis. How those two things fit together, I don't know, but that was sort of the business model of him and his partners. And Mr. Liebensohn says that Jonathan Chabin, who's kind of this friend or hanger-on of Kim Kardashian, who's been on Keeping Up with the Kardashians for a while. If you follow him, you probably know more about him than I do. But he basically, they say that Jonathan Chabin contacted him on Instagram, expressed interest in there being a partnership between Kim Kardashian and these guys who are making Censorgram, and they discussed like making a 50-50 deal. And then the story from Mr. Liebensohn is that that basically Kim Kardashian, they sort of start doing talks. He pitches her on the idea of Kimojis. A couple hours later, she sort of bails, trademarks Kimojis on her own, and then they have a falling out, and she goes off and just does this herself and takes this idea. And then he says that he basically mortgages his house, starts spending all his money on these lawsuits, trying to recover from her after getting threats from this Marty Singer guy, who's a very prominent attorney in Hollywood. And Mr. Liebensohn says that basically it ruined his life. So he files this lawsuit. He has to dismiss the lawsuit because he's running out of money. And that's one big thing that I'll get into is the sheer amount of money that he spent on something that to me does not look like it warrants or justified that amount of money. And I'll also talk to y'all a little bit about why you should be real careful hiring attorneys sometimes, because sometimes people can get basically rooked by their own attorney. And that's just, whether that happened here or not, I don't know, but I've personally seen it. I've personally seen friends try to hire attorneys, particularly in family law, and then get charged ridiculous amounts of money for things that absolutely were not justified by the the charges from the attorney. So did that happen here? I don't know, but I will say that we'll look at his lawsuit and see if you think it's worth what he says he paid, which was $200,000. So he basically says they got in this fight. He says his name was forged on a settlement agreement by one of his business partners because they were afraid of Kim Kardashian and her lawyers. And if you're wondering, Kim Kardashian is not yet a lawyer. You may have heard stories about that. I actually checked. I remember hearing that she did pass what's called the baby bar exam, which is like she's trying to be a lawyer through this alternate route. That's maybe a separate subject, I guess. But you don't actually go to law school in California. It's one of the rare states that still allows that. So she has passed the first part of the bar exam. She still has to go kind of be it's almost like an internship. You're kind of working under the tutelage of a barred lawyer in their offices, and based on at least the time frame, that's like a 4-year process. She passed a couple years ago. Is she still doing it? I don't know. I looked online. She has not become a member of the California bar, and it was about 2 years ago whenever she passed the first step. So that may be coming up. She may be sort of in the process of taking the final part of the exam, which is very hard. California bar exam, I can say, as a member of the California bar, it was much harder than the Texas bar that I took, and I had to study a lot more for it. So not surprising that it would take a while for her to go past that, not having gone to law school. Especially, it's impressive to have even passed the first step. So that aside, she is not one of her own lawyers. She has this Hollywood lawyer guy, and I'm going to show you this lawsuit that was filed, which gives a lot more details into it, and then we'll read an arbitration award that shows what ultimately happened with this, and see kind of what is the actual drama behind this when this guy's out there on social media saying that this happened, and should he have pursued this lawsuit or just maybe let this go. So what are we looking at here? You can see that this is something called a complaint. A complaint is the first document that is filed in any lawsuit initiating that lawsuit. And you can see this was filed in what's called the Western District of Oklahoma. So states, depending how big they are, they can have just one district. They can have multiple districts. Oklahoma looks like has 2 districts, Western and Eastern. And so Mr. Liebensohn is the plaintiff here. The plaintiff is the one suing, who starts the lawsuit. And you have Kim Kardashian West. She was married to Kanye at the time, and a company called Kim's a Princess Inc., which is what she named her California corporation. And you can see that Mr. Liebensohn is suing for what are called causes of action. A cause of action is a legal theory that allows you to recover money from someone for doing something wrong. And you can see that these are: 1, a breach of a partnership agreement; 2, a breach of a fiduciary duty. What is a fiduciary duty? A fiduciary duty is kind of like you owe a duty to someone because of a special relationship that you have with them that puts you in a position of trust. And so we'll see what he alleges on that in a little more detail later. Unjust enrichment is a theory. It's really what they call a remedy, which is like a type of damages that you can get. But sometimes, and in some states, it's what's considered its own theory for how you can recover. That's a whole big dispute, legal theoretical dispute that probably doesn't really matter. Fraud is just fraud, right? It's what it sounds like. Did someone defraud you? There's a whole bunch of things people have to prove to show fraud, and it doesn't have to be criminal. It's civil. It's a big civil basis for a lot of legal complaints, and we'll see a little more about that later. One interesting thing for this, you can see that the number of pages is 13. So this is a 13-page long document, which is part of what we'll get into when we talk about, was this worth the amount of legal fees he paid when he was mortgaging his house. So you can see this says, plaintiff David Liebensohn, that's the guy we saw earlier, alleges as follows. And he's just outlining stuff. At the beginning, he's outlining kind of who is everyone. He says he's a citizen of the state of Oklahoma. So while he is currently living in a car in the streets of Los Angeles, he used to live in Oklahoma. then that's where his like $2 million house was, which in Oklahoma I can tell you is a very, very big house. I'm from Texas, and they're probably smaller in Texas than they are in Oklahoma if you have that amount of money. In California, it would be a little not so big house. Then it says Kim Kardashian West is one of the defendants. She's a natural person, which just means that she's kind of a human being who can be sued. She lives in California, in Los Angeles. She's a celebrity and reality TV star. Her company, Kim's a Princess Inc., is just a California company, and it's got this address where they kind of like that's the offices of them. It's probably just a virtual office, so I bet I wouldn't suggest going there. And if you did, it's probably just nothing there. Then it says that it's wholly owned by Kim Kardashian for the benefit of her, and basically they're alter egos of each other. When it says that, alter ego is a legal theory. So the Clark Kent versus Superman. Clark Kent is the alter ego of Superman. Bruce Wayne is the alter ego of Batman. And so there is a legal theory called alter ego, which is basically you're the same guy. So your company is you. You didn't follow these sort of formalities of a company. You didn't follow the rules that make a company separate from a person. And so you treated them like the same. It was just like you called it a company, but it wasn't really one. It was all just you acted like it was just Kim Kardashian. And therefore you are legally liable for whatever the company did, and vice versa. So that's kind of that theory, which literally is just like the superhero alter ego concept. Then this is you can see this alleges that he's suing for he has diversity jurisdiction because he's suing for more than $75,000. Diversity jurisdiction is just a way you can get into federal court instead of state court. Diversity means that basically there are parties who live in different states on either side of the plaintiff defendant. We can go back up here and look at this. Sometimes we call it on the other side of the V. So V is versus, and Liebensohn is from Oklahoma. Kardashian and this company are from California. And this diversity and to have this kind of jurisdiction in federal court requires that you say that you're suing for more than $75,000, which is why he picks that specific number. And the idea behind this is basically sometimes when people are in different states, there's kind of a traditional view that state court can do what's called hometowning you. So if you're from California and you get sued in Oklahoma, then the judges there may favor Oklahomans. So that's just kind of the idea. Is that is true anymore where we're all kind of like a tied together country? Maybe not, but whenever this thing was passed, it's like or a long time ago. And in the 1800s, was it true that you would get hometowned if you were from California and you went to Oklahoma? Probably yes, and probably even more recently than that. And it still happens in some places. So the idea is people can go get yourself out of state court and get into a court where it's a little more neutral sometimes towards people from other states. And he wants to be in federal court for whatever reason. Sometimes you can get higher quality judges. Sometimes I think in federal court, so that may be why he wants to be there. That's just because it's considered more prestigious. So it's not like an insult to state court judges, but they're often elected, and federal judges are appointed and generally have to go have a real good resume to get the Senate to approve them. So it's also another aside. Venue is just like what part of Oklahoma is it appropriate to be in. He says it's Western District instead of Eastern because that's where most of this stuff happened. A substantial part of the events or omissions on which the claims are based occurred there. Now we get to the general allegations, and this is the part of a lawsuit or lawsuit's complaint rather, where Mr. Liebensohn is sort of telling his story. He says that in 2014, Liebensohn, along with 200 individuals named Narayan Shankar and Daniel Rice, founded App Social LLC. The general purpose of App Social LLC was to create applications for social media users. So basically, he and these two guys found this app company. And then he says from January to June 2014, Liebensohn, along with Mr. Shankar and Mr. Rice, grew the App Social LLC by creating applications that would enhance a user's social media experience. They developed an application called Censorgram, later changed to Censor Out, to protect social media users' accounts from bullying, spammers, and trolls on Instagram. It allowed the account holder to filter and automatically delete unwanted comments and hashtags and ban unwanted users. The account holder could easily filter any single username, hashtag, or word or phrase to be removed from their profile in any post, provided push notifications or emails to alert the account holder that the comments were removed. So that's an app that you might want if you might want your kids to have an app like that. You might want to be the one in control of it. Then you could filter certain phrases. You could stop certain people from contacting your kids. If your kids are being bullied, then they could stop that. So that's functionality that I'm sure sounds like a good idea to me. But he says he's the one who came up with this and with this group of people. And he says in early 2014, that App Social LLC also began to develop Wall Street emojis as well as provocative emoji content, which is how he apparently came to the attention of Kim Kardashian, who has sort of built her career on being a little bit provocative. I think she would even admit to that. So, I don't know, but I think it would be hard to deny. Then it says Censorgram caught Kardashian West's attention. It says on June 18th, 2014, Kardashian West's friend and social media assistant, Jonathan Chabin, contacted App Social LLC via Instagram Messenger, stating that Kardashian West was interested in the application and wanted to discuss her potential investment. It says Chabin proposed an 80%, 20% divide in profits, and Liebensohn and the other two members were not interested in this wildly inequitable split. And that's pretty, if you're getting 20% of your own company, you might not want to do that. Although Kim Kardashian's a pretty big brand name, so your company may be worth a lot more and more than 4 or 5 times more with her attached. And it says that then they got contacted again, and then again Kim Kardashian West wanted to partner with them, so they scheduled this phone conference for July 15th, 2014. Then Mr. Liebensohn, and this is his version of events. So when you're reading these, it's always the one side versus the other, and so we'll see Miss Kardashian's version a little bit later. This says that on July 15th, the Kardashian calls Liebensohn and Mr. Rice in Oklahoma, and they discuss their vision for the application, how Kim Kardashian could get them to the next level of exposure, how she had been using the application and her love of the application. It says during this meeting, Kardashian West admitted that she had discussed anti-bullying features to be implemented in Instagram with Instagram's CEO, but that Instagram was unwilling to implement a one-size-fits-all solution to bullying and preferred to handle comments on a case-by-case basis, which was not to Kardashian West's liking. And that kind of makes sense because you could see how Kim Kardashian would herself, like as a celebrity, be subject to a lot of people just trying to troll her probably nonstop on Instagram. I'm sure she gets like just the most ridiculous stuff. And so as a, not just teenagers would want this, also celebrities who are especially reality TV type celebrities would love an app like this or love functionality like this, especially in 2014 when things were a little bit less developed. So this says that they had a bunch of emails. The parties agreed on July 28, 2014 as the date they would meet in person in Calabasas, California, which is where the Kardashians are. And then this says that when Liebensohn, Shankar, and Mr. Rice realized they would be working with Kardashian West, they took the already developed Wall Street and sexy emojis and added Kardashian West's likeness. They shared the idea of Kimojis, a set of animated emojis and GIFs of the Kardashian family with Kardashian West. She loved this idea and insisted that she filed Kimoji trademark application to save costs. Kardashian West promised that they would promote the concept together as a team. Now, if this act is actually how it happened, I would say that's a big mistake. Frankly, before telling her the name, they should have tried to trademark that themselves, or at least documented that they owned it or whatever, or that it was their idea. Whether they could really win that, I don't know, because there's sort of squatters' rights type issues with that as to whether they would can they trademark something that's clearly based on her name? I'm not sure, but they could have at least gotten themselves a little bit more protection. And certainly, if you haven't signed the dotted line, and this is not one of your old friends, this is some random person you don't know. I would just say as a general principle, not talking about anything bad about Ms. Kardashian, but as a general principle, you want to have the business deal locked down before you start working on the business, right? So, and even I've got a business right now with one of my my law partner. He's a guy named Cyclone Covey, real name. He's one of my best friends from college, and we work together really well. But we put everything down in writing. It makes sure that there's no fights. Nobody has any disagreements later, and at least so far we haven't had any. These guys did have a disagreement and started having a big problem with their sort of relationship with one another pretty shortly. Okay, now the next paragraph says, on July 28th, 2014, the parties met at the home of Kris Jenner, Kardashian West's mother, in Calabasas, California. At this meeting, the parties finalized the terms of the partnership. They agreed that the partnership division would be 60% to Liebensohn, Mr. Shankar, and Mr. Rice, and 40% to Kardashian West. So that's a much better split if you're someone founding the application. It says App Social would contribute its skill, intellectual property, and ideas relating to Censorgram and the emoji content, and Kardashian West would raise $660,000 for capital contributions. So what is a capital contribution? It's basically just an investment. A capital is just in general, when people say that, they just mean money. So capital is money. It's money that you're using for a business to sort of invest in it. It can be other things too. But here is just I'm raising, $660,000 for guess that is the same thing, but 660,000 for money to like sort of get this thing off the ground. And it says, based on the understanding that the parties entered a partnership, Liebensohn, along with Mr. Shankar and Mr. Rice, showed their prototype for the Kimoji concept to Kardashian West. Kardashian West was enthusiastic about the ideas, especially the concept of provocative emojis. She said it was a great project that she wanted to pursue. So they're basically saying, Kim really likes the idea of, sending these, what I was talking about earlier, maybe YouTube inappropriate, not that inappropriate, but like it would pass muster on Instagram or something, but you don't want some teenager seeing this video and seeing some of these. They're not that bad. But then this, so she's raising the money, and then you can see Kris Jenner is, if it's at her home, that's maybe the business nerve center of the Kardashian empire, Kardashian Jenner empire, which probably would not surprise anyone that they would go do it there if you're watching their show. Then they say that on August 14th, 24, or actually, Liebensohn says on August 14th, 2014, Kardashian West called Mr. Shankar and asked if Liebensohn, Mr. Shankar, or Mr. Rice had filed the Kimoji trademark application. Basically, he's saying that she called his business partner and is like, hey, have you filed the trademark yet? And then Mr. Shankar informed her that they had not, and Kardashian West insisted that her team would file the application. Again, she insisted that there was no need for them to bear the cost. In reliance on Kardashian West's confirmation of the partnership, it was agreed that Kardashian West would take care of the Kimoji trademark application. And so part of this is to set up kind of like a, scroll back up real quick. See, they've got the fraud claim. One of the elements of fraud, and we'll probably see that later when we go through here, in order to prove fraud, you have to prove that someone made a statement that you relied on. And reliance is kind of a legal concept that means basically what it says, that you reasonably, like a reasonable person, when they heard that statement, would have thought it was true and would have like kind of done something or taken action or whatever in reliance on them telling the truth. And so he's basically saying, look, you went and lied to my partner and said it's all going to be cool. I'll find that trademark, no big deal. And then he's going to allege that Kim Kardashian pulled the wool out from under him. So it says on August 14th, 2014, Kardashian West filed the first trademark application for Kimoji, identifying the sole owner as her corporation, Kim's a Princess, Inc. And then it says, subsequently, on August 14th, 2014, after filing the Kimoji trademark application, Kardashian West called Mr. Shankar again. This time she demanded to know who Ryan was, and that's in quotes. Despite calling Mr. Shankar Ryan unprompted in her July 22nd, 2014 email correspondence. Kardashian West claimed that she just became aware of a screenshot originating from Ryan that contained personal information about Kardashian West's use of Censor Out, which is their app, and accused Mr. Shankar of disseminating a screenshot to all of Chicago. And what they're talking about here is, I guess they'll say in a second, but basically, like, I think some of these guys got a little celebrity happy when they were talking to Kim Kardashian. One of them takes a screenshot of some things that she was texting, and then she finds out about it through some friends. And so they'll talk about that in a minute. I'm going to show you a little lawyer trick live in case you're ever starting a business or want to know how to find a trademark and is something trademarked. I haven't actually done the search yet, but we'll see. I think we're going to find Kimoji and see what happened with it. But just, I figured when I started doing it, I was like, you know what, I'll go back and just show everybody how you actually do it. Because if you ever like are thinking, let's say you're in their position and you're like, I came up with this great idea, Kimoji, and I go start this business with that name. First thing you have to do and should always do before you lock down a name, I'll say two things. One, go search for the domain. Like, has someone registered Kimoji.com? Because the best thing to trademark is something where you can own the domain name, where if anyone goes and types in on Google, or Bing here, what the name is, they're going to hit your website. But then also, has someone else registered yet with the government? So how do you do that? This jumped a little bit. You'll see there's this thing called the USPTO, is the United States Patent and Trademark Office. And so what did I search for? I just searched trademark search USPTO. I've used the Internet Explorer browser, but Bing puts this down a little bit, so I had to be more specific. So I'm going to the government, the U.S. Patent and Trademark Office search database. They have this search database. They call it Trademark Electronic Search System. You don't have to really memorize all this. You could probably find it again, but just to know it's out there, and you can bookmark this video or something and come find it again if you want. Search the database. You can see they have all these search options. You can get real complex, but if you're just trying to find the name of something, I'm going to go here. I'm going to give them feedback, but they will type in Kimoji and see if what he's saying is true about at least when she found it. So this shows us there's actually a bunch of Kimojis. So you can start. They'll have here the serial number, the registration number. Those are just numbers to keep track of, like, what is the trademark number, because there's a ton of them, and people file a lot of different ones sometimes because they may cover different things. And so you can see this. This first one, that is for fragrances. All these trademarks are on different like uh, things, right? So they're categories. You can see all these codes. This IC is like a free US #1. That's because there's an international trademark system where if you ever get one of these, you can file both, like, for US trademark protection and for international. And the codes are category products. And so this one is fragrances. You can see it is Kim's a Princess. It was filed March 21st, 2017. But this is probably not when he's talking, probably later. Some of these are dead. This one was filed 2016. This is for, like, gifts, apparel, mobile phone cases, jewelry, and lighters. Again, Kim's a Princess. Got one filed bottoms, bodysuits, bathing suits, Kim's a Princess, May 2nd, filing December 27th, 2016. I'd actually find a lot of interesting information on here if you're ever trying to, like, track down stuff about companies. This one's December 27th, 2016. Again, Kim's a Princess. So she's just, like, grabbing every category of stuff that she might want to use it on or want to do something if they're trying to use it. Here's August 14th, 2014. This is for wireless electronic transmission of graphics. So you can tell that basically on that day she did actually file this. And it's a dead trademark, so she's let it die. That's probably because their App Store thing has been canceled. I don't think they're really selling Kimoji stuff anymore for that. And you might be able to find some more if we go in here. I feel like I'm doing the opening Al Capone's vault for, like, Geraldo. I don't know what I'm going to see. If you're young, you don't know what that is. If you're older, you know what kind of media disasters there can be doing things live. Geraldo promised everyone he's going to find Al Capone's treasure in a giant vault in a bank in Chicago, and there was like 2 pieces of paper on the floor inside. And he did it on live television and pumped it up for like 2 weeks before. So what is this that we'll find? They have this, the thing that, I'm going down to this column. This is where you find a lot of the stuff. This shows, like, everything that happened in the case. So they file it, and they start amending it and doing this stuff. Figure if you're interested in watching this detailed video, you might be interested. If you go over to documents on this, if you're ever trying to do this, you can find, like, what did they actually do? We can find their actual application, and we can see what Kim filed. So they filed this Kimojis thing. This is like from the form, attorney 14. I'm not sure if it's saying the time of it. May tell us the time here. 1928 Eastern Delta Time, Eastern whatever time. I think that's Eastern time. So that's like 7 p.m. Eastern, which is probably at some point in the range of when he's saying this happened. Up here, and that's that. They probably attached a specimen, so specimen is the back here. A drawing, they'll call it. Specimens are like, you're showing, like, here's an example of the thing that I'm either using in commerce or what, and she's just a word. Sometimes people, if they have a product, they amend the drawing in a month. Nope. Some kind of office action. Office actions just basically say they are challenging stuff. Like, the patent office is saying there's something wrong with it. So oops, she didn't sign this. So it probably is a little Al Capone's vault scenario here. There's nothing super interesting, but this is something like people who are, say, influencers or whatever, that, like, there's probably a lot of them watching, or people, everybody nowadays is, like, kind of looking at starting their own businesses and things like that. And trademark is always something that you want to get, because you'll see in this lawsuit that becomes a problem for these guys later when she does have the trademark, because that means they sort of protect. She is now listed as, or her company's the legal owner of it, and they're not on that listing. So back to the complaint, and let's start finding out what this drama is with Ryan. This guy, she says there's a Ryan. So they say they don't know what she's talking about when she says that you're disseminating a screenshot to all of Chicago of my personal information. And they say Kardashian's attorney, Todd Wilson, later explained that Kardashian West received a screenshot from Mr. Shankar's acquaintance, allegedly originating from Mr. Shankar. Kardashian West used this as an excuse to cancel the partnership. So he's saying basically she just made it up and it wasn't a big deal. It was just some little screenshot, and she's saying like you just dropped my stuff everywhere from inside your app that you were taking photos of, and I'm done with you. And they say the following day, on August 15th, 2014, Kardashian West, through her attorney Martin Singer Esquire, that's Marty Singer, the guy we talked about earlier, who's kind of a big Hollywood lawyer, sent Liebensohn, Mr. Shankar, and Mr. Rice a letter stating that they caused Kardashian emotional distress and defamation in excess of $5 million. Kardashian West also sent a settlement agreement and mutual release, quote, release, whereby Kardashian West would release Liebensohn, Mr. Shankar, and Mr. Rice from the $5 million potential lawsuit if they walked away from any future development of the Kimojis. There's a, let me see if I can find this. There's a version of the screenshot attached to the Daily Mail article about. Okay, so it's not actually a version of a screenshot. Sorry, it was a quote that the Daily Mail had where this guy told them what a little more about what it was. So it says Liebensohn said, "Without my knowledge, one of our partners took a picture of some words on a page that Kim used in our censorship app. No user handle or private info, just a little clip of a screenshot to brag privately between him and a friend. This friend was jealous and actually had a friend in Chicago that knew someone in Kim and Kanye's world. They intentionally sent the screenshot in the hope it would interfere. It did." Okay, so that does not really tell us what this was, what screenshot he took of in this guy in the Censorgram app. Mr. Liebenson's being very cagey about that a little bit. You can kind of see it was just some words, no personal information. This is entirely speculation, but I think it is probably an educated guess just from me, only from reading these public documents. You have an app called Censorgram. One of the things you might do if you were evaluating that app for the purposes it's used for, which is to keep people from posting like horrible content on your Instagram, is you might start typing in some of that horrible content or words that are horrible to see if the app actually works. I mean, the first thing that would make sense, it would be something that you would do. There are certain words that you can probably imagine some of them that if someone says they are horrible, they are slurs or whatever, and what if Miss Kardashian was typing in words to try to see if the app worked, and then someone takes a screenshot of that, that got out, people might misconstrue it, or you're looking at Kim Kardashian typing some horrible, awful, thing that nobody should type. I think that probably this is like maybe the one scenario where certain words might be okay to use, is trying to see if you could, like testing a computer app that would eliminate those words from your Instagram. But that's me. But I don't know that that's true, but I do suspect that that would explain this scenario. If she was going in and testing their app, it would make a lot of sense why she would not want whatever she typed to be spread around Chicago or anywhere else. I don't, again, that is just what I suspect would be something that someone might have in a Censorgram app if demonstrating it to someone. This probably be what I don't know. I might limit what I would type into something like that, but I would not. It doesn't freak me out, I guess, but it probably would freak people out on the internet if they saw Kim Kardashian doing stuff like that and did not know the context. So he says Mr. Liebensohn refused to sign the release. It says Kardashian filed Kimoji trademarks for cases for these are the ones we were looking at, some of these earlier. Cases for mobile phones, bathing suits, body tops, bottoms, flip-flops. I won't read all these, but it's just basically a bunch of stuff. She files one for fragrances. We saw that one. And it says she's currently being sued in federal court for trademark infringement on her Kimoji perfume line for her Vibes perfume. I haven't looked at that case, but it sounds like Kim got in a trademark suit. About 1 year later, Liebensohn learned that Kardashian West released the Kimojis application and saw Kardashian West promoting and marketing the Kimojis. So he's saying basically, I didn't even know she did this, and then now there's Kimojis. The Kimojis, originated by Liebensohn and App Social, were very profitable, as all parties had anticipated. Kardashian West continues to use and profit off the name Kimoji on products that are not smartphone applications, expanding to phone cases and perfume, for example, while it was Liebensohn, Mr. Rice, and Mr. Shankar who came up with this name. Liebensohn invested every penny and all of his time and effort to get the applications into the right hands. He walked away with nothing except financial and personal losses, while Kardashian West profited from his work without just compensation. And the last thing he says in this sort of fact section is in 2018, Liebensohn learned that Kardashian West was aware of the screenshot that allegedly originated from Mr. Shankar since before entering into the partnership agreement. On information and belief, Kardashian West never intended to follow through on the partnership agreement. Rather, she had the screenshot in her pocket and used it as a reason to cancel the partnership agreement after filing the Kimoji trademark application in the name of her corporation, Kim's a Princess Inc. Now, what's true of that is hard to tell, because they are sort of not really telling us like the facts. And I've got my guess about the facts that I gave y'all. That would, it might make Kim in that scenario, like she might be the looking at this thinking, oh, these people are are threatening to blackmail me ish or something like that, and it has distressed me, or they've already damaged my reputation in Chicago. If it was something innocuous, and we don't know that, and Mr. Liebensohn didn't really tell Daily Mail what it was, um, which at least, this is just me, from the outside, you're trying to look at this and sort of like ballpark what's going on. He is dumping like everything else in here. So like it just is sort of like I don't know if I'd call it a red flag, but like uh, something that's a little bit different, right? He's dumping all the other stuff, but he won't say what's in the screenshot. He says it's not personal. He says it's not a big deal, but he won't say what it is. And so you're kind of going, it's something negative for him. So I don't know. I don't know. I can't really think of anything else that would actually cause her emotional distress. So if it was something innocuous, then this, what he's saying is that, oh, she was just using this to sort of bully me out of my business. Which I don't know. It's very hard to tell from the outside. We'll see the arbitration stuff here and see what's going on with that. But right now we just have his version of events that we're looking at. Now let's look at what are called the causes of action. And causes of action are these legal theories that allow you to recover against someone if you prove all the parts of those theories. There's his first cause of action. That is a breach of partnership agreement. So he re-alleges and incorporates everything above. So he's basically saying those are the facts that support this. He says, I was a individual and as a third party beneficiary of App Social LLC, and defendants agreed to combine intellectual property, skill, knowledge, and financing with the intent to carry out a business undertaking, namely the development of Sensorgram and the Kimojis. What is a third party beneficiary? So that is a legal concept for contracts that says that sometimes people who aren't actually the one who signs a contract can enforce a contract. If the contract is, and the law on this varies a lot state to state, so I'm going to give you just kind of like a high level overview of the idea. It may be wrong in your state or different. The idea is basically that some contracts are kind of intended by their nature to benefit someone else. He's saying like, I'm the owner of this company, so any contract, presumably he's going to argue that, or would have argued, I guess, that made me this sort of intended beneficiary of the contract, such that I can enforce it even if I'm not one signing it. And so that law gets much more complex, which is why I'm sort of just making it aside. But that is the general concept, would be that there are certain situations where a person who has not signed a contract and can either enforce the contract, and actually in some cases you can enforce a contract against someone who hasn't signed it, although that is a little bit more rare, which makes sense if you start thinking about it. Then it says Liebensohn, Mr. Rice, and Mr. Shankar had a 60% interest in the joint venture. Kardashian West had a 40% interest. The parties agreed to share the profits accordingly. This constituted a valid and enforceable partnership agreement. The verbal agreement was further implied by the parties' conduct. So what he's arguing here, I don't think, let me confirm this real quick by scrolling down. Yeah, so basically there's not a signed agreement, but he's saying like, okay, we agreed to this. If you don't know about oral contracts, a contract can be made orally. People can go say, yes, we have a contract, and if it meets the requirements of a contract, there's a bunch of things you have to show. But an oral contract can be just as enforceable as a written contract. Vast majority of the time, people do contracts in writing. It makes a lot more sense. It keeps things where everyone knows there's no confusion, there's no disagreement. I would never suggest making an oral contract. You always want it to be writing, even with your friends, right? When I said earlier, my friend and I, like we wrote it down. It just keeps people from fighting. And so, like, really what he should have had her do is sign a non-disclosure agreement or sign some contract before getting into this, and then that would have affected him some, but it doesn't look like that happened. He says that Liebensohn and App Social LLC performed all the actions required under the partnership agreement. That is something that you say because for you to go sue on a contract, generally you have to sort of have followed the contract yourself. If you're the first one to breach, the general rule in most states is that the other person has been excused. Now, if it's what's called a material breach, which just means kind of like a breach of some term that's really important to the contract or a key part of the contract. So if you breach some real minor part, it doesn't matter. Like if it said your name has to have a period against it on the signature line or something that has no real bearing on anything. If you breach an important part of the contract, then you have then excused the other party and from their side, and you can't sue if you're the bad actor. not necessarily bad actor, I guess, but it's not. There's nothing like illegal about breaching a contract. It's just you're the person who caused the problem, I guess, for breach of contract claim. Um, and it says defendants failed to perform their obligations under the agreement by, without limitation, registering the Kimoji marks under defendant Kim's Apprentice Inc. and refusing to share profits pursuant to the agreement. Um, by the way, when I say there's nothing illegal about breaching a contract, I just mean like it's not criminal. It's not. You might have to live up to your bargain, and the law could make you do that. But there's no law that's going to be like you have to go pay a penalty or you go to jail or something like that. It literally is just worst case, the bargain is enforced. So he's saying I did fulfill my part of the bargain. Kim didn't because she registered this trademark and then she didn't share the profits that we had said 60-40. She just kept everything. He says that was unjustified, it was unexcused, and he says I had damages in an amount that I believe to be not less than $100 million. And he's probably just sort of guessing at that number. Now we get to the second cause of action, which is for breach of fiduciary duty. That is when someone is in a position of responsibility towards you that's sort of they have obligations to you to take care on your behalf, and then they breach that obligation. It's a little harder to prove here to me. Just as a lawyer looking at it right away, you're thinking that this claim seems a little harder to prove because usually this is restricted to things like a trustee of a trust who you're the beneficiary of, or like a lawyer would probably have fiduciary duties to their client because like I'm in a position of knowledge and authority, you as the client or not, so I have to take kind of special care for your interests. A nursing home taking care of an elderly person or something like that. That's usually the type of thing that rises to that level. This says he agreed to this sort of business undertaking. Parties agreed to share profits. There's an oral agreement, so he makes clear that he relied on the protections of the partnership relationship that defendants should have provided. He created the value and developed valuable information, technology, concepts, and marks, including as related to sensorgram, censor out, Kimoji, and sexy emojis for the benefit of their partnership. And he shared their information openly and freely, reasonably expecting that all disclosures would be used for the benefit of the partnership. It says that defendants sought to and did exploit the partnership's information, technology, concepts, and marks solely for themselves, and unlawfully exclude Liebensohn. Defendants knowingly acted against Liebensohn's interests in communication with the partnership. Defendants refused to share Liebensohn's profits pursuant to the partnership agreement. Further, defendants identified Kim's Apprentice Inc. as the sole owner of the Kimoji mark, and that she says that that representation to the USPTO was patently false and fraudulent, as he did not consent. Again, $100 million in damages. It's a little attenuated theory. If partly because it's this oral agreement. If you had actually like made a company and then Kim Kardashian was the CEO of the company, then I think the fiduciary duty thing would have been a little stronger, or like a legal partnership where she was appointed the general partner. General partner is sort of someone who is the one managing it for the other people. Then that is a kind of situation where you might or it probably depends a lot on state law, but where they could be a fiduciary to the person who's like a non-managing partner. An oral agreement seems like I kind of doubt they put in their conversation who was in charge or what or anything like that, the level that might lead to this. Then he talks about unjust enrichment. That's a legal theory where if someone has money that sort of comes from you or that is yours, that it's unjust just on sort of like they call it equity. Like if the judge just looks at it and thinks, that's not really fair, that's unjust. And that really is what it is. There's not so much like there's some legal test for it, but it's sort of vague, like just kind of use your head or your heart or whatever and think, is this fair or not? And you can give money back. And so he's asking it for it under that theory. That may or may not be a theory, or it may just be a remedy that he can get for these other causes of action, but that I don't actually know Oklahoma law on that action. Like in California, for example, you can't actually put this out as a separate cause of action. Will get dismissed, and it's not a big deal. You basically would say, "Oh, I get it. I get the money, but for unjust enrichment, but you have to prove, say, fraud or one of these other three first, and then the damages are you get money that you had unjustly." So that's like a technicality. It doesn't really make any substantive difference that I've seen, but it is sort of the rule sometimes in some places. Fraud is again fraud, and he's saying that what did she say that was false? She made a promise to divide the partnership profits 60-40, and she promised to raise $660,000 for this capital contribution. Promises were false. She never intended to do this. He says that she basically like she was aware of the screenshot that she broke the partnership up over at the time that she made the promises, is what he's saying. So he's basically saying that I guess that this screenshot existed like before they even went and had this talk or this discussion. And so Mr. Shankar had already taken pictures of her in the app saying whatever she said or typing in whatever she typed in. And he says that she basically just like sat on it and then came in and made a partnership and then terminated the partnership. He says the promise was made, promise for all this partnership stuff was made to get him to rely on it. That's one of these elements of fraud, that you have to reasonably rely on the promise. You can see him saying that here. Shared the prototype for the sexy emojis application on Mr. Shankar's phone as he described it. And if he had known of Kardashian's actual intention, then he never would have provided the Sensorgram intellectual property or the Kimoji name, idea, or prototypes to defendants. That is why you have a non-disclosure agreement. Looks like they didn't do that with a famous celebrity. They might have been sort of like, oh, wow, I should just go do it. But you have something that's really secret and you are going to talk about a business deal. I will say, even with those, I've seen I used to do patent litigation, and you would see something that's very common in the patent world is big companies, very big companies, would go just have meetings with a bunch of like small companies, and they would see their stuff, and then when you get into this, and then go make their own version. And when you get into discovery, which is like this, I get your emails, I get to read what you did behind the scenes. You're just reading people going like, yeah, let's copy that. And so that is an actual tactic that a lot of very large companies use, is to go have meetings with people, learn all their stuff, and they have no intention of doing a business deal. And an NDA only really protects you if you have good enough lawyers. So if you've got your own business, if you're the startup, you should be careful what you show to people, because there are big sharks out there and people that you will know their brand names, you will know who they are, and they will still do stuff like this. Um, Not talking about Miss Kardashian there at all, but I am talking about some companies that I'm just not going to name. Um, this says uh, at the time defendants' promises were made, at the time Liebensohn shared information pertaining to the Kimoji name, idea, and prototypes, was ignorant of the falsity of defendants' promises and defendants' secret intention to keep the profits for themselves. Defendants took full advantage of Liebensohn's trust and reliance on defendants and their business expertise. As a result of the above described acts, Liebensohn has suffered monetary damages in amount according to proof at trial. So he's in, yeah. And then he also wants exemplary and punitive damages. And those are the same thing. Exemplary just kind of is punitive. The idea is set an example, and punitive to punish. So let's set an example and punish her. Lots more money. So he wants this 100 million. Punitive damages would be on top of that and all this other stuff. So that is his complaint that he files originally. And what happens next after that? So after that, in Oklahoma, this motion gets filed, and we're going to see this one's mostly blacked out. It's called filing under seal. So they have taken the vast majority of this and sealed it. That means that the public can't see it. It is supposedly confidential. We will get to see a lot of it later because they just filed it not under seal in California. This is what looks like pretty much the same stuff, but at least right now that it's hard to even like read any of what they're arguing. But you can tell the high level. So what was she filing? Kim Kardashian files a motion to compel arbitration pursuant to this law, or dismiss pursuant to these parts of the federal rules of civil procedure, or to transfer the action. So it's do any of these three things. Dismiss is like you haven't, assuming everything you said is true, it's not enough to prove a legal claim. Some of these look like personal jurisdiction is 12b2, I believe, which means why are you suing me in Oklahoma? I've never been to Oklahoma, would be the argument. Or to transfer, which means go send this back to California, because courts can do that. Federal courts can move it around if there's a more appropriate location. The big part of this that is important and that ended up being what happened is that they asked to go to arbitration. So a contract has a clause require that you can waive your right to go to court. You have probably done this thousands of times and don't know it. People will put this in their arbitration or in their contracts. It's a clause that requires you to basically do things in private, in a private arbitration in front of usually retired judges, and you'll see that's what happened here. They don't have to be judges; they can be just random lawyers, and they decide your case like they're a judge. It's a lot shorter than a lawsuit. It's structured a lot like a lawsuit, but with a lot of the parts kind of chopped out or condensed, and that makes it a little bit cheaper. Although not in this case. So as well as we'll see. So the lawyers, there are certain lawyers who know how to spend money, and that's how they make money. So you can see a high level. This is an index that shows what she was arguing mostly. She's redacts some of these facts. We can't see it. He's arguing, I'm a California resident. I have no contact with Oklahoma. a whole section on compel uh, all the claims to arbitration. It says, here's the personal jurisdiction, which is I don't have any contacts with Oklahoma. That's a whole analysis. I probably should do a video about that someday, but that not today. It's way too complicated. Then fails to state a claim, which is like you just don't, and you can see that's only one page, which probably not the. I actually thought he probably had enough facts to state his claim in there. Claims plural. So you see this is these are all like legal cases that she cites in the brief. You do this, you give this like table of authorities to show the court like what pages each case is on, that can be helpful sometimes to the court or the court clerks. Starts making these arguments, and most of the rest of this is picked out. So I'll just sort of the parts that are not that interesting. There's this declaration where from Kim Kardashian, and so we'll stop at this one because she shows some of it. And she's basically saying, she's the CEO of Kim's a Princess, sole director. I've made 4 visits to Oklahoma for family reasons. None of them had anything to do with this complaint. That's not going to be enough to sue someone in Oklahoma. I've never lived in Oklahoma on its own anyway, I guess, like, well, really family reasons. But you're sort of look at every contact she has with Oklahoma, and is that enough to like overall lead contact? It was just visits for family. That's not really a big thing. And she's like, my company has nothing to do with Oklahoma. We never solicited people there or whatever. He says that Kim's a Princess owns the mark, but she's not the one, and that company's not the one selling the products. It's these other entities. She probably has brand deals like where she gets cut, and the other companies like she's getting a percent, and someone else makes the app or does whatever. He says this would be burdensome to be out in Oklahoma, and here's my declaration. A lot of this deal. Here's Martin Singer, shot attorney, and you can see he redacts out all the stuff he's saying. So not much there. But what happens next after they start asking you for arbitration? This is something, and it is about to get very interesting. Or I'm going to go on a rant for a little bit in a second. So you see that he does a notice of dismissal. What is a notice of dismissal? He's basically saying, I'm voluntarily dismissing the claim. There's 2 ways you can dismiss a claim. One is with prejudice and without prejudice. And you'll see he does this without prejudice. What's the difference? Sometimes you want to dismiss your claim with prejudice, which means you can't raise it anywhere else again. The reason that usually happens is because you settled. So if you see a plaintiff going and filing something saying, I dismiss my claim with prejudice, that almost always is a settlement of some kind. Who it benefits, who knows? You can't really read much more into it other than somehow they've resolved this. Because the plaintiff is saying, I will never file this again. It is with prejudice. When you do it without prejudice, there's some other reason. It's less common. But here, the reason is the plaintiff's dismissal of his claims is done with the intention of pursuing such claims in arbitration. So probably what happened, or what I would say is the lawyers probably decided we can't keep this in court anyway, although we're going to see what he says in a minute, which will spark my little rant. Okay, so this is a quote from this Daily Mail interview he did, which is how I found out about this. But apparently this guy's all around TikTok, and actually you can see him down in Los Angeles, and I've talked to people about this, and apparently they've seen him out there with his sign. He's this Liebensohn guy in his interview said he claims, wrongly advised to withdraw the suit after getting into $200,000 worth of debt from legal fees. So you see that we just saw the 2 things that they filed, and just so you know, he had not filed really anything else that I saw on this. It was very short. They call it a docket, which is a list of things that happened in the case. So he basically just filed that complaint that we looked at that was 13 pages long. And he is saying here, which was just blew my mind looking at it, that he had spent $200,000. He was wrongfully advised to withdraw the suit after getting into $200,000 worth of debt from legal fees. Let's look at something else. This is another part of his Daily Mail interview, and Mr. Liebensohn said to them, he says, we couldn't even get to the stage where we could show evidence in court and get them to explain themselves. They're just so good at skating around the truth, and I was going to basically need to come up with another 100,000 or more to keep playing the game in court, said Liebensohn. My lawyer told me to withdraw the lawsuit, which I did, which is a nightmare. I had to sell my house to fund the legal fight after already putting everything into the business, which was once worth $2 million and fell apart after the Kardashian. And here is the rant. Okay, $200,000 is what he said. So he said before $200,000, and that is what he had spent up to date on this lawsuit as of the time of this thing being dismissed. That complaint was 13 pages. That is nothing. Like, you as a non-lawyer may have no idea how much time it takes to do one of these. I would guess, like, if you said I had to do a complaint for 13 pages, how much would it cost? If I had to personally do it, I would max ballpark that thing at 10 to 20 hours, and that's like the max. And my rate is around, I think it's 775, or well, let's do 800. I remember, I think we might have upped it a year, which just, it sounds like a lot, but that's, there's like a matrix of fair fees or whatever, and we're just putting it at what it is. And most of our fees get paid by the people we're suing, not by our clients. But so let's say I spent 20 hours as sort of a more senior attorney, because I'm around 20 years experience, which is why it gets that high. $800 an hour, so like the max you could expect to pay for that with me doing it as an attorney living in the Los Angeles area, which affects the amount that you bill to, would be like 16 grand to do what we had seen. Probably I would not be the one doing the work. I would assign that down to an associate. And our associates, like, let's say they're probably not, some of them are 400-ish or so if they're younger, if they've been doing it a few years, and they're certainly competent to do what we saw there. A lot of that, not all of it, but some of it was boilerplate that wasn't even like not all 13 pages were brand new stuff that some attorney would have written. So if they took 10 to 20 hours, that would be more like, maximum, 8,000, 4,000 to 8,000. Not $200,000 worth of legal work that I was looking at. He is saying, and whether he's telling the truth, I do not know. So really, in the abstract, I will say, I don't know if this actually happened here, but there are many other cases where this happens, where attorneys just like waste time and overbill at a level that's extreme. And this happens especially to sort of people who are a little less experienced in the legal field, don't know that that's out there and waiting for them. Um, what this guy's saying here, like, if he really spent $200,000 to get to that point with that complaint, that is nuts. It should not have spent that amount. There's nothing that I can conceive of, even with Kim Kardashian threatening him, that would be that amount. I can point you to another example of this. Another thing I saw that made me go like, "Wow, what was the attorney doing?" If you ever watched this documentary on HBO called The Inventor, it's about the Theranos case, and in the Theranos case, there, which is this sort of case where you've got this woman coming up with a fake box that supposedly did DNA blood tests. If you put your finger in it, then it would take blood, and it was often these convenience stores, and it was going to test you for every disease ever and all this stuff. And Theranos went bankrupt because it was all just a scam. And but they did not want that scam getting out there. So when one of their employees became a whistleblower, and he goes to the Wall Street Journal and starts like leaking out stuff, they start threatening him. They get a real big law firm that was on the board of Theranos from a very prestigious lawyer, who was doing things to sort of try to scare the guy into not talking about what was going on at Theranos, which was the fraud. And although people in the company kind of knew, like, oh, this box is not real, they are faking the tests. And there's a moment in that documentary where he starts saying, yeah, my parents, they kept sending me letters threatening me. And then they would not file the lawsuit. They would say, I'm going to file a lawsuit. And then every week I would get one. And then like they would say, on Friday, I'm going to file. And then they wouldn't. And my parents mortgaged their house for $500,000 to pay an attorney just to deal with these letters. And I heard that, and I was like, that is the most insane thing that I've ever heard. Because if I'm that attorney, if I get I don't care if he's the best attorney on the planet, I don't care who you are. You're coming to me going, I will file a lawsuit Friday, and then they don't do it, and then 5 times they do that. One, how do you spend $500,000 of attorney time responding to that, no matter how many times they do it? 2, my first, or maybe second response would be, put up or shut up, right? Like, if you send me another letter, I'll file the lawsuit, and I'll start talking in public about everything my client knows about your little box. And what are you going to do then? And what do you think Theranos would have done with any attorney of any competence whatsoever saying that? And it does not cost me $500,000 to write a letter saying, I'm going to go file a lawsuit about your box if you send another one of these, pieces of paper that I don't care about. So go shove it where it belongs. Like, I mean, you can do that, and you can resolve one of these things for nowhere near that price. And I heard that, and I imagine an attorney, I don't know whether what the guy's saying is true or not, but he's saying pretty much the exact same scenario of them just moving paper around and pretending to do work they didn't. And I've seen this multiple times with people I know, or people coming to me with these problems of attorneys doing stuff like this. Family law is an area that I've seen this repeatedly in. The reason is because I think regular people are more likely to get into it. The amounts that are being charged are not $500,000, but they're amounts where, like, if your custody of your kids is at stake, you will go into credit card debt for 10 grand if some attorney tells you they're going to get you out, get you custody, or get you out of a bad relationship, or get you a divorce from some scenario where you have an abusive spouse. And those are kinds of things I'm seeing this in. And attorneys Um, there are bad attorneys out there who will try to bill you amounts and not do work and pretend they're doing work and whatever, and you just need to be aware of that. Did it happen here? I don't know. If this guy really got billed $200,000 for that 13-page complaint, then I will say yes, that is outrageous and should not have happened. And I would just warn you, just because you hire an attorney on something, especially family law cases, especially cases where like you are in some kind of emotional stress, which is what this guy was in. You have to make sure if you're getting a bill for a large amount that you check what's going on, because and get a second opinion. Like you are allowed to ask another attorney, is that fair what I'm being billed for? Because I've seen people get into situations, and I do pro bono cases on stuff in California sometimes. I don't have time to do them forever, so please don't bombard me with calls on it, because most of these are like for you know people who are friends of family members, that type of stuff. But see this stuff come up, and it is not something that I've seen enough, I've gotten enough calls, enough people talking to me about, oh, here's this attorney, and then you start looking them up, and they've been disbarred or all this other stuff. There's more misconduct than you might think from people who are professionals and have these licenses. So be careful. That is my rant, and then I'll come back to the Kimojis. Okay, so Kimojis. So what happens after he dismisses his claim? They go to arbitration, like he was talking about, and we don't. That all process happens in private, but in this case, we actually get to see a little bit of what happened, because they did after the arbitration was over. Kim Kardashian won, and she did something that you can see here. That's called a petition to confirm arbitration award. What is this? So an arbitration award, when you win an arbitration, um, the award only really gets legal effect if once you go to court after. So confirmation of an arbitration award means that you are going in to a court saying, "Hey, look, this arbitration happened. I want to make it a legal judgment. I need you, the judge, to like stamp off on it." The judges do not really. It's very hard to appeal these arbitrations, and by very hard, I mean very, very, very hard. And they because it's supposed to be like a final process, but the judge comes in. He says, "Okay, I'm the court. I am making this into a legal judgment, and you can take that and you can use it just like it was an award after a jury. You can take that judgment, you can just start collecting money, or you can enforce it if it says don't do something or do something or whatever. You can come to court, and now you can come use the court system to make people do what happened as a result of the arbitration." I'm gonna scroll through this document a little bit, but this one has a little interesting stuff in it, but is mostly I'm less interested in this thing itself and more what is attached to it. Now, but there is one thing that is a very notable change you may not have noticed on this one from what we saw before. When we looked at the Oklahoma lawsuit, it only had this guy, David Liebensohn, as a party. Party is someone who's actually in the lawsuit, not just a witness or something like that. But now we have Mr. Shankar, who we talked about earlier, and we have Daniel Rice, who is the third guy in the partnership, and we have these two companies that from Oklahoma, which are their companies, Sensorgram and App Social. So that, to me, I think we get into a little drama here with this, and a little maybe like starts being a kind of what is these three people are now all parties, where before we only had Liebensohn saying that he hadn't signed and he was the only one suing. So we'll talk about that a little bit later. Now there's been a decision against all of these people, not just Liebensohn, and it says, and here's what Kim is saying about this, about what happened after the arbitration is over. In 2014, respondents authorized their attorney to settle a dispute with petitioners, that's Kim and her Princess Company, arising from respondents' wrongful conduct. That's all of those respondents. The parties entered into a settlement agreement and mutual release, the settlement agreement, dated August 29, 2014, to resolve petitioners' significant multi-million-dollar claims of defamation and violation of Ms. Kardashian West's right of publicity and privacy rights. That's going to be from that text message that supposedly was being spread around. Or I guess it wasn't a text message, it was a screenshot of something in the app. The settlement agreement includes an arbitration provision, states in relevant part, here's this arbitration clause, and it's kind of just a standard one that says basically, we're not going to do this in court. It'll take place before JAMS, which is an arbitration company, or not really company. Well, I guess they are kind of a company in Los Angeles, heard by a sole arbitrator who's a retired California state or federal judge. This is kind of the key thing, them having signed a settlement agreement, because it really changes the odds of winning the case. If Mr. Liebensohn or any of these people has signed a settlement, that makes it much harder to then go sue over stuff that happened before the settlement. If you waive all your claims, release everything, then you're basically having to overturn the settlement you signed. And we're going to see there's going to be some dispute about whether Mr. Liebensohn actually signed it. He says his signature was forged on it, but by one of his co-partners who's now part of this. And that's the part that to me was like, what? Like, I've not heard an explanation for that. And it does tend to make it, I'll explain what I think about it in a little bit. But again, we're looking from the outside. But so as an attorney looking at this, that does make me think you were in a much worse posture in terms of trying to resolve this. And I'll also say, like, there's not really anything in private that could happen, again, that would add up to this $200,000 just to get to a settlement like that. Drafting that, whatever, sending letters back and forth, it is sort of inconceivable that you could send enough letters and drafts to add up to $200,000 plus a 13-page complaint. But that's me. Then this says that for several years, the parties abided by the terms of the settlement agreement. Then in late 2018, respondents retained new counsel. Okay, and that's a key thing because it also means we don't know what he's saying, but if he spent the $200,000 on the new counsel, or did he spend it on the old counsel? That could be a big difference. Is like, if who's wasting the money there? If he spent, $10,000 on the complaint, and then the other attorneys charged him $190,000 to do the settlement agreement, then I definitely would be, it affects a lot who is sort of, if there is overcharging, would be responsible for that when you've got these two attorneys involved in this. I don't know any of that. I just know that I've not seen and can't really think of a way that he could be justifiably billed that much. This says he, at least if his description is right, and it's coming from him, so who knows. Respondents retain new counsel to represent them in a bad faith attempt to invalidate the settlement agreement, which they and their former attorney had negotiated, agreed to, and signed. And then it says, on August 13th, 2018, in a demand letter sent to petitioner's counsel, that's Kim Kardashian, respondents, who is this group of people, first took the position that the settlement agreement was unenforceable, alleging that respondent Liebensohn's signatures, individually and on behalf of the companies, so you can sign on behalf of a company if you're like the executive, then that binds the company, but it's, when it says individually and on behalf, it means he signed for himself as a person, and he signed as the executive of the companies, were forged. That respondents Shankar and Rice signed the agreement under economic duress, and that the agreement was unconscionable. So Liebensohn is saying his signature was forged, and the other two guys are now saying in this demand letter, which was before that other lawsuit was filed in 2019, that the agreement was signed under duress and was unconscionable. These are two ways you can invalidate a contract. Duress means economic duress is sort of like there's you're under this like undue pressure. Like a classic example is like, I put a gun to your head and say, sign this or I will shoot you. That contract is not enforceable. like you do not, like, it's not like some technicality like, haha, I got you to sign it. It is not enforceable because you're under what's called duress, which is this sort of pressure that's improper. And that the agreement was unconscionable. Unconscionable means essentially that the agreement is one-sided in a way that shocks the conscience. That is a high-level description of it. It is much more complicated, but that's what they were saying. It says that the petitioners, which is Kim Kardashian, promptly brought a demand for arbitration before JAMS with an attached statement of claim, the demand, on December 21st, 2018. So Kim files this demand for arbitration in JAMS. A demand is kind of like a version of the complaint that we just saw, but in arbitration. So you draft out kind of a very similar thing. You can do it. It doesn't have to be the exact same way, but it states your claims and the facts. And she says her demand pled all these are other legal causes of action. Same thing, like declaratory relief means declare my contract's valid in this case. I'm asking for you to declare some statement of law. So she says that she sought relief that declaratory relief, that the settlement agreement is binding and enforceable. Injunctive relief, which is in order to do or not do something, which is in order to abide by the terms of the settlement agreement. And in order of stopping or forbidding them from asserting that the signature was forged, and damages for repudiating the agreement. Okay, now Kim starts describing what happened to this arbitration, and we'll see what the judge said. You see this Terry Friedman, retired, the honorable. Honorable means judge. That's the title you get when you're a judge. You're the honorable. And retired is just a note that's like, okay, I'm not judging more, but keep my title and I keep my honor. So Kim says, throughout the arbitration proceeding, the undisputed facts completely contradicted respondents' concocted allegations of forgery, duress, and unconscionability. It was abundantly clear from the evidence obtained through discovery that there was absolutely no factual basis for respondents' repudiation of the 2014 settlement agreement. In fact, the evidence showed that the respondents, by and through their former attorney, negotiated the terms of the 2014 settlement agreement, consented to those negotiated terms, and signed the agreement enthusiastically. And then this says the arbitrator entered the final arbitration award, fully disposing of all claims in the arbitration. You see that was Exhibit B to this declaration. I have that, and I'll show you what the judge said in a minute. Because when you do an arbitration, they give this award, and not all the time, but sometimes they do they call it a reasoned award, which is where you give all your reasons, you put in kind of the work to like write out like essentially a legal opinion, and that's what happened here, which outlines kind of like what the judge thought about the facts. And then it says the arbitrator, who is also a former judge, so I'm calling him judge, but he is the arbitrator in this case, determined that the uncontroverted evidence showed that the parties were of legal age and represented by counsel when it was negotiated. They all consented. The object was to resolve significant claims of defamation and violation of her rights of publicity and privacy rights. It was supported by sufficient consideration in that it released respondents from a $5 million potential liability. Consideration is a requirement of a contract. That means that something of value is exchanged back and forth between each parties. So it just means like if you're just giving someone money, that's a gift. If there's obligations or releases or whatever, something of value on each side, then it's a contract because it has and something that's binding and can be enforceable. Sometimes gifts too, but that's a separate video. There's a lot of any of these legal issues. I could just go on forever about them, but it's we don't have time for a full law school. Then this says that basically that there was a declaration of the respondent's former attorney Brian Cohen, which established that their signatures were valid and neither were forged nor obtained by duress. So their own attorney apparently gave a declaration, according to Kim, saying that the signature was not forged of Mr. Liebensohn. And then the arbitrator found there was no unconscionability, like we were talking about earlier, where that the settlement agreement did not shock the conscience. And this stuff is all going to be in the arbitration award, so we'll just look at that. The rest of this is just kind of law about what happens when you try to confirm one of these arbitration awards. So now I'm going to show you the declaration, really because it has this award, which gives us a lot more of Kim Kardashian's version of events instead of just the other side that we already looked at. Here's this document, and what this is it's a declaration that was filed. A declaration is just like a sworn statement, and it's of this Todd Egan, which is I believe one of Ms. Kardashian's attorneys, and it's in support of this motion to confirm the award. So basically, they're saying here's some factual stuff that supports my motion to make this arbitration award into a legal judgment. And he sort of lays out some of the facts about what happened. Here's this arbitration. Part of what he's doing here is laying out the attorney's fees that they spent to do the arbitration and this motion, because they're seeking attorney's fees from the guys who claim they started Kimojis. You see, just this motion that we're looking at with this declaration costs nearly $10,000, $9,225. And so you can see how that's kind of like what one of those would cost, but also you can see how that's like roughly in line with my estimate of that complaint and that motion we were looking at to confirm the arbitration award plus this declaration, probably roughly the same amount of pages. So even at his rate, which is $7.25 an hour, which is not out of the realm of doing that, an associate, you can see. So basically, he's quoting, and I actually had not looked at these rates before quoting that, but he's roughly about the same estimates that I had for an associate. You can see he puts more time for the associate than for than himself, which a lot of times is what will happen. It helps like kind of save money when you put more time to the associates usually. And then you can see Mr. Singer, who's like this hotshot, as of the date of this, was billing $1,200 an hour, which is a lot. And maybe not a lot these days. This is 2020. We're in 2023. Rates have gone up a lot over the last couple of years with inflation and everything. But that's just a little tea about lawyer fees. And the key part here for those who care about the Kardashians more than lawyers, is the settlement and the arbitration award. So this is a lot of what I think was being redacted in that earlier motion. So they show the actual settlement agreement from 2014. You can see that this is between Kardashian, Kim's a Princess, Mr. Shankar, Mr. Liebensohn, and Mr. Rice, and then their companies. And this is an example of what settlements agreements kind of look like. You can see they sort of define some of the stuff. What are emojis? What are Kimojis? A lot of this is just legal language. And they get into the terms. Like everyone's always like, no, we all deny any liability and whatever. And then what do they agree to here? So they agree that Kardashian's not prohibited from making her own like censorship app or her own emojis, including the brand name Kimoji or any other celebrity emojis. They start calling all those other people, Liebensohn and all those other guys, the censorgram parties, just so it's easier to reference them. She says that they agree and stipulate that she's not in violation of this section, and that they have no right to uh, any app that related to Kimojis or the Kardashian app, and they acknowledge that she's like her her apps basically don't violate their rights. They agree they won't use the name Kimoji. They agree that Kim Kardashian has the sole rights to Kimoji. They agree that they won't use Kimoji. Yeah, basically, you won't use Kim Kardashian's name or likeness or anything to promote your apps that you're doing. Kardashian agrees that, and her company agrees that Censorgram can go do their own censorship app, and that because you see it says absolute unfettered right to develop and market and whatever. So they still have the right to do their own app. They still have the right to do their own emojis, but they can't brand it under the name Kimoji or reference Kim Kardashian. And then Kardashian agrees that she won't incorporate any portion of the Censorgram software, and that she agrees that she doesn't have a claim to any of like the actual emojis or the app that they developed. And then she releases them from like all kind of claims that they have. Censorgram releases. It's like they call it a mutual release, where you're both just like, any claims I've got, they're gone. This is like a standard waiver in California because there's a section of the civil code that says that you generally don't waive claims that you don't know about unless you put in something like this. Non-disparagement means we won't talk bad about each other in public, which is sort of going on right now, I guess. Otherwise, I wouldn't be making this video. Confidentiality means we'll keep a bunch of stuff confidential. And they sort of limit how you can use it. And there's remedies, which an injunction is just like an order saying don't do that again. This is that arbitration clause. If we're going to go to arbitration, they'll put like, oh, if you have something to do with this agreement you want to fight over, send the notice here to this address. They give their emails. A lot of these are just standard clauses in contracts. So you can see what hurts them a little bit. These Censorgram guys is that there's an attorney's fees clause that says whoever's the prevailing party, the one who wins, if there's a lawsuit about this agreement, gets their attorney's fees, reasonable attorney's fees, which means like the standard amount for the value of the attorney services. It's not necessarily even what you paid. And execution and counterparts just means you can go sign it on your computer and I'll sign it on mine. And even though they're like separate, like you see, these are blank. So what's happening here is this in counterparts means Kim signed this version, and then everyone's signing the page like on their own, but that they don't all have to like get the same page together and sign it. So this one's Shankar, he signed his page. This one's Liebensohn, and he's saying that the signature was forged, but you can see this is kind of the same. I'm not commenting on whether it's a forgery, but at least purports to be the same. Well, maybe a little different. That one's a little loopier, but I'm not a handwriting expert, so they've got this and this for him in the individual capacity versus in the co-founder capacity. But then Kim says that here's this award that will get to the version of like, what did the retired judge in this case, Judge Friedman, say as acting as the arbitrator? So gives this award and he gives an introduction into it. He's considered all their submissions, their documents, and he is issuing an award. So he says, Kim Kardashian's a celebrity, she's an entrepreneur. Kim's a princess is her company. Here's these other people who develop applications for social media users. He says he finds the parties entered into a settlement agreement to settle a dispute. On December 21st, 2018, Kim brings the demand for arbitration to enforce this, to try to stop the respondents from going to court. And that the lawsuit was filed after this. So basically the timeline is that the Censorgram guys, Mr. Liebensohn, they send Kim a demand letter. She's like, oh, they're going to sue me, so I'll go to arbitration first, and then they go file in court, and then everyone just sort of decides they'll do it in arbitration. Then he's kind of just outlining here's what everyone saw. We talked about that part. The court issued the following scheduling orders. Scheduling orders are just, like he says, establishing procedures in the arbitration. So the arbitrator can be like, here's the schedule. You'll do discovery. You may do deposition. You may exchange sort of questions back and forth with each other, which is called an interrogatory. And it looks like there was document productions and motions and motion for summary disposition. So someone tried to get this out before the claimant, which means claimant here. Kim because she Kim because she filed it, so she's the claimant. Claimant is the one who claims, and so in a lawsuit they'd call you the plaintiff. In an arbitration, you'd be the claimant and the respondent. So she asked for basically knock this out without even having the hearing, and this says that the judge granted this request for summary disposition, requested additional information, which was going to be the attorney's fees information, and then he granted attorney's fees. So he basically found, without having the arbitration, that the agreement's binding. We don't really need to do this arbitration, but I'm issuing a ruling. So here he gets into this decision on the summary adjudication. So he's sort of just talking about a bunch of legal stuff. Here's when a contract is formed, when they're capable of contracting. Taking of legal action or the threat to do so cannot constitute duress. So he cites a legal case to that effect, which is probably what they were arguing was the duress. It was like, she's threatening me with a lawsuit, so now I'm forced to settle. Court may refuse to, and now he's setting, like, what is the law for when something's unconscionable? There's sort of two ways to do that, and you can see he gets into it. Procedural unconscionability focuses on the existence of oppression, such as unequal bargaining power, such that there's no real negotiation, surprise, or when there's like a boilerplate form, like those things you sign online. Sometimes you click like, yes, I agree to terms. Here they had a lawyer, which makes it real hard to claim unconscionability. Substantive unconscionability is when the terms are one-sided or really harsh. And it's putting the elements of all these sort of legal claims, and all this is sort of not as interesting as the drama. And then here's the facts that he finds. And the facts are more like what he decided happened based on looking at the evidence. He considered all the documentary evidence, the proffered evidence, and so even though they didn't have a hearing, he's going to have been submitted, like what we just saw with the declaration. They'll have attached a bunch of documents. Declarations are the written sworn statements. The exhibits are the documents. So he says he finds that Liebensohn, Shankar, Rice, and Liebenson's signed. That's a little error. Signed NDAs that prohibited them from disclosing information about Kardashian or family or business. Then on August 14, 2014, Shankar sends an email to his attorney, Wilson, stating, there was this oversight of security on our part. I take full responsibility for this, that it will never, ever happen again, and that we are willing to sign an even stronger NDA. So this is the guy, Shankar, who supposedly like leaked or allowed to be leaked one of his friends, whatever was in this this like screenshot. Singer, who's Kim Kardashian's attorney, sent a demand letter to respondents on August 15, 2014. That's what the Liebensohn was saying. Oh no, the attorney sends this to me. They negotiate a settlement. There are two sets of revisions to the agreement by the counsel for respondents, which is the Censorgram people. So their attorney has gone through this twice, which is important to the unconscionability. Basically, like, did the attorney get a chance to look at it? And then it says the respondents, the Censorgram guys, then authorized their attorney Cohen to negotiate a settlement with Kim Kardashian. The judge says on September 7th, 2014, Liebensohn, who's the one suing in Oklahoma, sent an email to Cohen stating, which is an attorney, stating in part, we have a verbal partnership agreement we would like to expedite, by which respondents would exchange ownership of Censorgram for the actor Quentin Aaron's likeness to be the face of Censorgram, and for Bad Boy branding, providing expert media exposure. The email also stated, we want to sign the release from claimants and hopefully sign with real partners within the shortest time possible. On September 11, 2014, Liebensohn sent an email to Cohen stating in part, we appreciate your understanding of this being time sensitive. I had to pause and try to figure out what's going on here, and I'm not sure if I have or not with this Quentin Aaron. He is an actor. He's been in a bunch of sort of bigger movies, but I'm not sure I didn't recognize him or if he had a big role. When I started searching for him and Kim Kardashian, it looked like maybe there is some connection because he had gone and gone to some party or something that she had. That's not much of a connection. So I can't tell, is Quentin Aaron associated with the Kardashians somehow such that they're exchanging his likeness, or is this just a side deal? I don't really know what this is talking about or why it says they would exchange ownership of Censorgram, their whole company, for the actor Quentin Aaron's likeness to be the face of Censorgram. So I don't know why they would be doing that, but sometimes it's hard to tell, right? Because we don't have all the documents that the judge was looking at, or to put this together. It says that Cohen, who's the attorney, he sends a red line revision to the settlement agreement to these Censorgram guys, Liebensohn and them. Redline is like if you haven't used Word, it shows changes in red. So you can kind of see what the original was and what someone has changed. It says that each of the respondents individually replied to their attorney that they liked and accepted the revisions. The attorney for the Censorgram guys plus Marty Singer exchanged these red line drafts of the agreement, which means the lawyers then start going back and forth on revisions. Cohen, the attorney for Censorgram guys, emails those guys and Leopardi. I don't think he's mentioned yet. I'm not sure who Leopardi is. Attaching execution copies of documents memorializing the partnership between respondents, Quentin Aaron, and Bad Boy, which is this kind of branding media company. This might be some kind of separate agreement going on in parallel that they needed to like resolve things with Kim Kardashian to get that done. I don't know. It says their attorney emailed a final red line and clean versions of the settlement agreement to the respondents on October 23rd, 2014. That's, again, the Liebensohn team. And then Rice, who's one of the Censorgram guys, responded to his attorney by emails at his signature and Liebensohn's signature on the signature page for himself individually and on behalf of Censorgram and App Social. Their attorney Cohen sent an email to all those guys saying, "I've received Shankar's signature." Then Cohen sends to Marty Singer the signature page of the settlement agreement on which each respondent had signed individually and Liebensohn had signed for the companies. And then he starts citing the stuff in the agreement that we already talked about. Says both these companies, these Censorgram companies, are canceled entities as of this time, according to Oklahoma Secretary of State. All the parties abided by the terms of the settlement agreement until 2017. And then Liebensohn contended for the first time that he and his the other respondents and his wife were not represented by counsel when they signed the NDA. So I think that's part of maybe why they're talking about that side agreement with Quentin Aaron, is that maybe it was just going on in parallel. But the fact that if the attorneys is negotiating multiple agreements, that kind of shows like, hey, you actually were represented, which is important to, was this unconscionable? Someone who has a lawyer has a much harder time showing it. And the judge is basically like, no one ever said that this was forged anytime prior to August 2018. So apparently the judge is saying at least even in August 2017. So Liebensohn starts challenging the agreement out at the sign, starts challenging the agreement on 2017. And then until a year later, he didn't say his signature was forged. And then for the first time, then he starts saying, my signatures were forged, but these other guys were signed under duress and it was unconscionable. And so those are the facts that the judge finds. And the judge says this agreement is valid, it's enforceable, and the uncontroverted evidence is that this was, like, particularly the declaration of their attorney Cohen. Apparently, we don't have that declaration, but apparently the attorney said their signatures were valid and there was no duress. It's kind of, I don't know why he's signing that. A lot of the stuff you're wondering how it's getting in here, because it seems like it would be privileged, but we just can't really tell. Attorney-client privilege might protect this, but I don't know what's going on that's gone through that or why they've released it. They may have like sort of released part of it, which can waive your privilege. He says Kim Kardashian performed her obligations under the settlement agreement. She released the claims. She didn't disparage them. She didn't disclose confidential information. This demand letter that the Censorgram guy sent repudiated, which means, like said, I renounce the settlement agreement. And except for that, Kim Kardashian, if that hadn't happened, Kim Kardashian would continue, performing. The respondents say that says that they, like, basically for a long time they'd only had these defenses we talked about. There's no admissible evidence that supported or established any of these defenses, according to the judge. It says that now they come up whenever Kim moves to sort of decide this on the papers instead of at a hearing. They come up with a new theory, which was that the settlement agreement was procured by fraud. They say that Kim Kardashian tricked them into agreeing to the settlement agreement by concealing the fact that she already had the screenshot from the censor out application. And Liebensohn and Rice contradicted each other as to who pressed them to sign the NDA. Liebensohn had had a declaration saying that Kris Jenner pressured them to sign this NDA, while Rice says it was Marty Singer, Kardashian's lawyer. It could have been another lawyer, and that's just what they're saying. I don't know if any of this is true. Judge certainly does not seem to have believed it. He says this contradiction further buried respondents' due defense. So basically, the judge is saying you're not keeping your facts straight, and that's why I don't believe you. And then he has here's the attorney's fees. So it looks like Kim Kardashian's lawyers charged $438,000 in total just to do this arbitration, and that is not a crazy amount for the amount of. Let me go here. We're at 24. I just want to make sure I can find my page again. You can see how many orders happened in this case, and there was motions to compel, and apparently, we don't even know was in. This is a lot of orders for an arbitration. Usually, you get one, sometimes two. For simpler cases, this is kind of a bigger one. So they're treating it a lot more like a lawsuit, which is why you're seeing these amounts of attorney's fees. And again, this is more. If you've never seen attorney bills, this is what they can look like. Todd Egan is the one of these lawyers, when we saw who signed the declaration, he bills $200,000 worth of time. Marty Singer is $86,000. Here's these other attorneys from there, and the costs are things like fees or deposition transcripts, whatever. And Egan's a 20-year lawyer, which is why his rate's pretty similar to mine. Singer is 40 years, and he's high profile and specialist, so he has this higher rate. These other associates, they start citing their law schools. What are their rates? Are they justified? So now he's kind of just justifying why are the fees so much? And then now apparently these guys on the Censorgram side, apparently he says it looks like they sort of have a falling out or something and start getting separate lawyers. So he says the judge says one of these lawyers, who was the lawyer for all of them, sends an email saying there's a conflict of interest and you have to get your own counsel. Sounds like maybe they were fighting on their side. And this kind of seems to confirm that. He says that the judge says, Liebensohn consents to this lawyer withdrawing, which just means I'm not your lawyer, you go get a new one or do whatever you're going to do. And he's still talking to Rice and Shankar. And then he says they're passive litigants in the case. I'm not sure what that means. They're not really doing anything in the case is what it sounds like, but I've kind of wondered why are they there? Because especially if there's allegations that one of them might have forged the signature. Shankar says that he sends emails to JAMS, the arbitration group, and he says that without his or Rice's acknowledgement or consent, Liebensohn hired California counsel in the case, sent out press releases and an audio tape exposing details about the case, hired a law firm in Oklahoma to prosecute that federal action, which is the one we first started with, and failed to pay JAMS fees despite telling them he'd paid it. Shankar says he never got a copy of his deposition, and the reason the attorney's fees are so high is because Liebensohn is doing all this stuff, and he says he blames Liebensohn for introducing this scapegoat of I didn't sign the settlement agreement, and says that this lawyer that Liebensohn hired told him that Kim Kardashian's lawyer told him. So we're through this is a game of telephone, and I'll just go through that again. The lawyer for Mr. Liebensohn tells Shankar that Kim Kardashian's lawyer said during the deposition that Kim Kardashian would not seek fees from Shankar or Rice. So this guy apparently sounds like he's in this arbitration without really knowing the lawyer's doing all this stuff, which would be bad. Although it doesn't look like it went well for him anyway. And then Rice, the other member of the trio, sends an email to JAMS. He says, I also didn't know about these press releases or this audio recording. I was never sent depositions like I was supposed to get, copies of my deposition. And now he's blaming Kim Kardashian's lawyer, Todd Egan. And he says, actually, Todd Egan told both me and this lawyer that he should not seek fees against him or Shankar. He says, I don't have any money. I can't pay these fees. And then Liebensohn says, please give me 60 days for new counsel to find a new lawyer, basically. Then their old lawyer says, I haven't received any response to my request for additional time. I don't represent Liebensohn anymore. The attorney's fees are too high. And their abuse of discretion, which means that they're outside what a judge could reasonably do or an arbitrator could reasonably do. And the judge says, you didn't support your request for an extension. I denied it. The deposition officer said you actually did get your declaration and your deposition and you never responded. So what this is all talking about with these depositions is if you go do a deposition, the court reporter who's going to be the deposition officer, will send you like a transcript of your deposition, and you get a chance to read it and say, is what I said accurate? Like, did you make any mistakes when you wrote down what I said? Which can happen because court reporter's trying to like hear you if you like if you're talk a certain way, if you have an accent. Certainly when I have automatic transcriptions of my voice, you get some strange things sometimes because I've got at least slight Texas accent or slight Texas drawling, and so um, they get a chance and they're complaining they didn't get a chance to do that. And the judge says, deciding this case was not a close call. Claimants prevailed because the evidence overwhelmingly established that respondents sought to disavow their execution of the settlement agreement without any justification. To the contrary, respondents concocted a false claim years after entering the settlement agreement that Liebenson's signature on it was forged, that Rice and Shankar signed it under duress, and that it was unconscionable. Then at the last minute of this proceeding, they abandoned these false claims and adopted a new, equally unjustified fraud defense. That is why the arbitrator determined that claimants were the prevailing parties. Then he does this analysis on, it's called a lodestar analysis, which is a whole other thing about, you're supposed to like do this analysis of like, are the fees justified? He says, yeah, they are. This is a great law firm. I'll decrease the fees a little bit because it says that the amount that they billed was somewhat disproportionate to the demands of the case. It wasn't super complex or expansive, so I'm going to like cut your fees by 15%. Not unusual, not really a knock on the attorneys. It's just sometimes judges will like be like, that's a little too much. I'm going to cut it down, and that's not like, he's not really attacking the attorneys or anything when he's saying that. Since I've gone on the rant, I want to make clear that like this type of reduction is not abnormal because sometimes things take longer in the case. A 15% difference is not a ton. If you are billing, if something should cost $7,000 and you bill $200,000, that is a problem. So this amount is just sort of like standard, I'd say, in terms of like sometimes just have more up or down amounts compared to what the judge would think is like the amount that should be billed. Then he basically says like, you're totally wrong. I don't believe any of you. Here's my award. Yeah, and basically gives Kim Kardashian everything that she wanted in her arbitration. So who's in the right on all this? And did Kim Kardashian completely ruin this guy's life over the Kimojis? The judge certainly did not believe them, and he has made the final decision, at least from a legal perspective. Kim Kardashian has been legally found to be in the right on this, and the judge is the guy who saw all the evidence. We can't see everything that was submitted in private. What do I think? I don't know. I can't see all the evidence either. I will say there do seem to be a lot of inconsistencies on the side of Mr. Liebensohn and what those guys were saying. Part of it is like, so if Shankar forges Liebensohn's signature, then why is Shankar in the lawsuit? Like, if you're the guy who forges a signature, why are you now trying to go undo the settlement and sue Kim Kardashian? I would think that he would stay away from this. And then also when you have all three of them, two of them are saying, no, Liebensohn hired this attorney on his own and he put us in here and we didn't even know what's going on and we just sort of weren't really part of this. They do seem to be changing their stories a little bit. And if two of the guys didn't really want to be part of this, that's very, very strange to have them in here, really even like in general, because they're like why would Liebenson's signature be forged by his partners and then they're suing because they would then be the wrongdoers if that's the case. So I don't know. They did seem to have an attorney negotiating this. Their attorney seems to have given declarations that supported Kim. I am not, at least what I have seen does call into question a little bit the claims that they're making because there are these inconsistencies. So why is this life ruined? I would say kind of, maybe you should have just given this up. I mean, like if you're in a situation, I know you're like, oh, I could have been the Kimoji guy. But on the other hand, a lot of the reason the money's coming in is probably because of her brand name and her name, Kim, not really the phrase Kimoji. She probably could have called it something else and had another cute name for it and still sold just as much or almost as much or whatever. But sometimes people, they get in their thing and they just won't get out of it. And the old Rosebud sleigh kind of thing with William Hurst, which if you don't know what that is, you can go look it up. Old movie. And so don't go pursue things like that. Definitely the legal system, if you're an entrepreneur, you got to be careful about trying to use the legal system as like a way to go get your big pot of money because lawyers will bill lots of money. And the thing I would say about a legal claim is if a legal claim really is great, then usually you can find, I won't say usually, but often you can find an attorney to take it on contingency. And if they won't, they'll usually tell you why. The reason this claim, like I would not have taken this case on contingency because he signed the settlement agreement. So when he signed that settlement, it just makes it real hard to get past that because judges are going to look at it going, you settled this. And that's why he's coming up with this, oh, my signature was forged, or wherever that's coming from. I don't know. But you can see how the judge was kind of like, well, if it was forged and you probably knew about this for a while, then why did you just not say anything about that until 2 years later, or really, no, it would have been like 4 years later, I guess, 2014 to 2018. So when you've signed a settlement, it's very hard to go back and redo your claim. If he wanted to do a lawsuit over this, he really needed to do it right away, not after having settled the case, if that's what happened. And I would, so if you are in this situation, don't get stars in your eyes, because if you just mortgage your house to do a lawsuit and you go, put all your money into it, then that can ruin your life. And so um, that's bad. It's horrible that happened. Who's at fault? All we have is the judge's order. So if you want to see more videos like this, more celebrity lawsuit explanations, answering legal questions about consumer issues, just random stuff like that on my channel, hit subscribe. There's probably the end screen things around here on the channel with maybe some more videos to watch, or the subscribe button. Here are all kinds of ridiculous lawsuits that I go through at a more detailed level than you usually get to hear about on news stories and stuff like that.